Mr. Wanyama?
Yes, my lord. My lord, briefly, we have filed a preliminary objection on point of law. It is dated 30th of July 2021. And then we also have grounds of opposition dated 29th July 2021. My lord, my colleague is surprised that we are very much efficient. We served him with a response even before he had served us with the application. My lord, the correct position is that he had served us with a court order. And in the court order, we thought the court order was sufficient enough for us to file a response on the question of stay. So we didn't even need to see his application, my lord, because what we were expecting him to do was quite obvious. So, my lord, that shall not be an issue. But, my lord, the fundamental question, which it appears, and I'll be mentioning this, is being raised in this court for the first time, which I'll go into that. But the fundamental question, my lord, is whether you have jurisdiction. Because of the decision of the Supreme Court in the New 2 case, and subsequently clarified by the same Supreme Court in the case of Geochem Middle East versus Kenya Bureau of Standards. I believe this is the latest authority. It clarifies this, for the avoidance of doubt, the judgment of the Supreme Court in New 2 and Synergy cases.
It is Geochem versus?
Geochem Middle East versus Kenya Bureau of Standards. It is at page 90 of our list of authorities filed before court, page 90 of our list of authorities. It's a judgment of the Supreme Court, the latest judgment by the Supreme Court.
You say page what? Page 190?
It is at page 90. The judgment is at page 90 of our list of our list of authorities.
Yes.
My lord, it appears that the Supreme Court has now clarified that in accordance with Section 10 of the Arbitration Act, the courts are not supposed to interfere with arbitration proceedings. Their role is so diminished and very narrow. And one of the ways in which the restriction has been made is in Section 35 and Section 39 of the Arbitration Act. But the legal implication of that is that the provisions of the civil procedure rules, don't apply with respect to arbitration matters. They don't apply with respect to arbitration matters. My lord, that is also the finding of the Supreme Court in the New 2 case. The New 2 case is at page 111 of our list of authorities. New 2 Aggravate versus Airtel Networks Limited, where the Supreme Court has again clearly stated that the civil procedure provisions don't apply with respect to arbitration matters. So the question then is, how is a person supposed to go to the Court of Appeal The Supreme Court has also said that the provisions of the Appellate Jurisdiction Act don't apply, as it were. So the right of appeal.
The Appellate Jurisdiction Act or the Court of Appeal rules?
My lord, both the Appellate Jurisdiction Act and the Court of Appeal rules, they apply on normal appeals. My lord, they apply on normal appeals. Such that the law governing appeals from under Section 35 of the Arbitration Act is this decision of the Supreme Court, the clarification by the Supreme Court. So how then is one supposed to go? For a person to appeal a decision of the High Court under Section 35 of the Arbitration Act, the Supreme Court has said the Court of Appeal must grant that person leave to appeal. They have clarified that in the Geo-Chem Middle East case. And they corrected the Court of Appeal and said there must be leave granted by the Court of Appeal on the conditions which the Supreme Court has set. And the Supreme Court is saying to shield arbitration proceedings from unnecessary court intervention, there must be leave granted by the Court of Appeal. My lord, we understand that the applicant here has sought leave from the Court of Appeal in accordance with the decision of the Newton case. He has sought leave from the Court of Appeal. My lord, it will have been different because in the Newton case, actually the High Court itself granted leave. It would have been different if my colleague had sought your leave. But there's no application before you for leave to appeal your decision on this particular matter. So the next available then opportunity is for them to go to the Court of Appeal for that particular leave. So my lord, the Court of Appeal has not granted that leave yet. And they have an uphill task. That is for the Court of Appeal. We will make those submissions to the Court of Appeal on whether they merit the grant of leave or not. But for our purposes, then we cannot not follow that path of intended appeal to say that we are filing an intended appeal to the Supreme Court, to the Court of Appeal, and therefore we have an automatic right of stay in accordance with the provisions of Order 42, Rule 6 of the Court of Appeal rules. Because, my lord, Order 46, Rule 2 of the Court of Appeal rules don't apply. Order 42, Rule 6 apply in cases where there is an automatic right of appeal. And therefore you come to the judge and say, I filed my appeal. I need stay for these reasons. Otherwise, on where leave has not been granted. And my lord, even in this matter, even if we were to stretch the argument further, they don't have an appeal yet. They don't have an appeal within the confines of Order 42. They don't have an appeal yet. What they have are pending applications in the Court of Appeal. So that even if we were to stretch that argument further, they will not warrant the exercise of the jurisdiction of this court. So, my lord, we are saying that in terms of the procedure, this then Court of Appeal, my lord, the High Court lacks jurisdiction in accordance with the Newton case and the Geo-Chem, as clarified in the Geo-Chem case, to interfere with these arbitration proceedings, especially its enforcement. You lack jurisdiction. Let them go to the Court of Appeal and plead their case there, but not at the High Court. So, my lord, the provisions of the civil procedure rules that you can set aside, you can review your own decree, don't apply. They don't apply.
Yes?
So, my lord, I urge that my colleague looks at that judgment again, the judgments in the Supreme Court, because they have clarified and corrected the Court of Appeal. In fact, in the Geo-Chem case, they have corrected the Court of Appeal by saying that with profound respect to the Court of Appeal, The Court of Appeal cannot entertain, cannot say that we have automatic right of appeal, that we have jurisdiction to hear this. They said, no. The jurisdiction is extremely limited. So, my lord, on that basis, on what basis really is the applicant then seeking to move the court in the light of these decisions? So the proper remedy, my lord, is for them to go to the Court of Appeal and push their case there. My lord, there is no imminent risk for enforcement of the decree. There's no imminent risk. It's unfortunate that the applicant has been caught in that legal quagmire. But my lord, these are arbitration proceedings. When the government participates in arbitration proceedings, my lord, they should be treated like any other party. They cannot run to the sanctity of the provisions of the Civil Procedure and Appellate Jurisdiction Act for comfort. They are bound with the stipulations of the Supreme Court, just like any other litigant. Because of the overriding principle in arbitration proceedings, that arbitration proceedings must be concluded very quickly, notwithstanding the parties involved. And my lord, this is based on the provisions of the Section 10 of the Arbitration Act, which has been borrowed from the unicitral model law on arbitration, on the need for courts to allow expeditious conclusion of arbitration proceedings. So having chosen to participate in arbitration proceedings, the government, just like any other party in the litigation market, cannot claim special rights. That is why you don't attach the assets of the government. We have the enforcement proceedings in the form of JR, which you have agreed to set aside until this court determines this application. So, my lord, there is no imminent risk for the court to extend any interim orders. There's no imminent risk for the court to grant any orders which they are seeking because you don't have jurisdiction. But my lord, what is more intriguing for us, you look at order number 2, my lord, that this honorable court be pleased to return the suit premises to the respondent to continue with its operations. My lord, have you seen that, my lord? It is completely shocking. My lord, having pronounced yourself in accordance with Section 35 of the Arbitration Act, this court has no jurisdiction at all to interfere with the decree, to interfere with the arbitration award, or to interfere with the decree. How can they seek, my lord, this kind of order? Are they not going to argue the application for refusal to recognize the arbitration award, setting aside award, my lord, again through the back door? My lord, that they want you to return the suit premises, the subject of the arbitration award, to us, so that this matter quietly ends. Yet, my lord, we are submitting that the rights of the parties have crystallized into a decree of this court. So, in the same vein, this court lacks jurisdiction to interfere with the arbitration award or the decree. So, my lord, I urge that you reject that request as put in prayer 2 of the notice of motion application. So, my lord, but because they have come to court, so this is what I was arguing, my lord. It is something new. The Supreme Court has not said it. The Court of Appeal has not looked at it. My Lord, assuming that, because I'm putting this as an issue for consideration by the court, my Lord, assuming that you don't have jurisdiction under the civil procedure rules, as said by the Supreme Court, because these are special proceedings. My Lord, do you have jurisdiction then to grant stay? My Lord, can you order with conditions? My Lord, can you order, for example, can you order as a judge, can you order that they deposit the decretal sum to court in court? Can you make that particular order? My Lord, our submission that this is one of the matters then which is special. That, my Lord, one of the ways for bringing the arbitration proceedings to a conclusion, now that they have the leave, they are seeking for leave to appeal in the Court of Appeal, my Lord, our submission is that this court has inherent powers to protect the public policy requirement for the conclusion of arbitration proceedings. And in its inherent powers, it can order that part of the decretal sum be paid to us. It can also order that because the applicant has sought leave from the Court of Appeal, and we don't know the outcome of that decision from the Court of Appeal, whether they'll be granted leave or not, then the decretal sum can be deposited in court. The court can make that special order, not under the provisions of the civil procedure rules, but under its own inherent powers. So, my Lord, this is the uncharted waters, especially, my Lord, because the party who is supposed to honor the decree is the government of Kenya, a unit of the government of Kenya at the devolved level. So it makes then juridical sense for the court, in protection of the principle that arbitration proceedings are supposed to be expeditiously concluded, then to call the applicant to account by giving that particular order. My Lord, under the provisions of Article 165 of the Constitution, this court has inherent powers for the ends of justice, to make certain orders which are expedient for the ends of justice, even if these orders have not been pleaded by the parties. If from the pleadings of the parties, that is the only order which this court can make. So, my Lord, in summary on that point, we submit that for the expeditious conclusion of the arbitration proceedings, then this court has, notwithstanding the provision of the Civil Procedure Act, has the inherent powers to promote that public policy, the public policy principle in the Arbitration Act and in the unicitral law. That the sums in question be deposited in court or in an interest earning account maintained by the parties. And then the applicant can go and seek his leave in the Court of Appeal. My Lord, the flip side, because that's one of the possibilities. The flip side is that you decline jurisdiction, let the status remain where it is, but let the applicant seek his leave to challenge your decision in the Court of Appeal. So, my Lord, those are the only two orders which can be issued in this matter, my Lord. Considering the decision of the Court of the Supreme Court on the special jurisdiction of the Court of Appeal on arbitration matters. So, my Lord, I urge that you consider our request. and decline to grant to hear that application on account of jurisdiction. And if you are to hear, then it must be in accordance with the principles set out in the new 2 case and the GeoChem case. And my lord, then you can move and exercise your special jurisdiction to promote this arbitration by asking them if they are really serious. Because, my lord, so far, they have refused to talk to us. My lord, don't record this. My lord, off record, my lord. We've been approached with an offer. They are saying that we will pay you 100 million in full and final settlement. My lord, can you imagine that, which my client has rejected? Off record. We've been approached. I don't know whether my colleague is aware, but I don't expect him to be aware because we've been approached by the governor's office that they pay us that in full and final settlement. We said no, that one we can't accept. My lord, as I said, my lord, don't record this. My lord, on the other issue, we had agreed with Mr. Kibanga that the parties will talk, really, that we will talk. And then after that, he went mute. My lord, there are 83 missed calls in Kibanga's phone from myself until I gave up. I don't call him anymore. My lord, I don't call Kibanga anymore because he refused to pick my 83 times over a period of 2 months. So, my lord, you can see.
It's a senior citizen, they could be forgetting.
No, my lord, he's here because we had agreed that we are going to meet to assist our clients. We don't take them through this path because, my lord, the other issue which we are raising is a question of interest. Now, my lord, interest accumulates daily, which is not in their favor. My lord, what if they lose in the Court of Appeal? What if they lose in the Court of Appeal? The interest will be colossal. So it's better we settle this matter. So my lord, I'm just urging my colleague, as you give us a date for your ruling, my lord, let them come and talk to us with the proper financial request, so that my client can consider. So that, my lord, we bring this matter to an end and we save the public the interest which this decree continues to accumulate. My lord, that is all from my end. My colleague's turn now. Thank you.